Hi, so good afternoon, everyone. Welcome to our Squire Patton Boggs webinar on managing small-scale redundancies. My name is Jo Galbraith. I'm a director in the L&E team at Squire Patton Boggs in Birmingham and half of a job share. And I will be joined today by my colleague Danny Vasilino, who is an associate also in the L&E team. A little brief bit of housekeeping before we get started. We will try to save time for questions at the end. We do have a lot to get through today. If you have a question as we're going through, please can you click on, there should be a button to the bottom right of your screen that will say Slido, or it might say Show Apps. If you can click on that, and then you can put a question in the Q&A. And then, as I said, we will try to get to them at the end of the session. We will circulate the slides and the link to the recording after the webinar as well, so everyone will have access to that. And so briefly, the aim of today's webinar, we're going to talk about practical advice on the key issues around managing small-scale redundancies. We're going to talk about the procedure, so that's pooling, selection, consultation. We're going to talk about bumping, alternative employment, and then we're going to talk about some practical stuff, some of our own learnings and our own experiences in advising on small-scale redundancy processes. We are not covering collective consultation today. That's a whole nother area that would take a lot longer. But I think in general, redundancy, this is a timely webinar. Redundancy is certainly a topical issue. This is not a surprise to anyone, but the economic climate we are living in is very challenging and uncertain at the moment. The CIPD Winter 2024 Labour Market Outlook has said that there is a significant increase in planned redundancies in the next 12 to 18 months. And it's something that we are seeing, I am personally seeing quite a lot with clients that we act for. I would say at the moment, I'm not doing a lot of large-scale redundancies, a lot of collective redundancies, but I am doing quite a lot of smaller scale, I suppose slightly under the radar redundancies. So I think it's a reflection of the geopolitical complex times that we're living in. It reminds me of that saying, or is it a curse? May you live in interesting times. I think we are certainly living in interesting times at the moment. Next slide, please. So this slide is just showing you a really broad overview of the steps required in an individual redundancy process. Again, nothing to do with collective consultation. This will be a much bigger slide if we were talking about collective consultation. So this is just individual consultation on a small scale redundancy where there's less than 20 redundancy proposed at one establishment within a period of 90 days. We'll talk through each stage of this process in a little more detail as we go through the session today. As a reminder, we always, as lawyers, we always look at it from sort of the end point, I suppose, from the negative side of what happens in the worst case scenario if you end up in a tribunal for an unfair dismissal. And what does the tribunal expect for an employer to have shown in order to achieve a fair dismissal? Very simply, you need a fair reason and a fair process, and you will then have a fair dismissal. But that, as we all know, is much easier said than done. So we're going to help you get there. And redundancy is one of the 5 fair reasons for dismissal under the Employment Rights Act. We will go on to explore the statutory definition of redundancy in a bit more detail. But the starting point is it's a potentially fair reason, and you also then need the fair process. The burden of proof is on the employer in an unfair dismissal claim. The initial burden of proof is on the employer to show that the reason for dismissal is redundancy. And if and when you establish that, the employment tribunal will then go on to consider whether you as an employer have acted reasonably in treating that as a sufficient reason to dismiss, taking into account all the circumstances, including the size of the employer, the administrative resources, etc. As always, the employment tribunal will consider the band of reasonable responses. So it will only be found to be an unfair dismissal if the employer has acted in a way that no reasonable employer would have acted. So it is still a relatively high bar for an employee to show that they have been unfairly dismissed. The decision must be so far outside the band that it's unreasonable, as long as you have already established your fair reason of redundancy. The ACAS code on disciplinary and grievance procedures does not apply to redundancy situations. It's a fairly common misconception that it does. It doesn't apply. So in the event of a finding of an unfair dismissal in a redundancy context, there's no possibility for the compensation to be uplifted or reduced, as it can be in all of those other scenarios, on the basis of an unreasonable failure to follow the ACAS code, unless the tribunal finds that the redundancy is a sham. And then there is the possibility for that uplift or decrease by up to 25% for an unreasonable failure to follow the code. But that's fairly rare, I would say. ACAS has produced guides on redundancy, which are useful, practical. I think ACAS codes and guides tend to be well used and well liked as a kind of user-friendly, employer-friendly manual in a lot of areas. So the redundancy ones are good. There's also a lot of case law in this area. Because I think redundancy situations tend to be very fact specific. So there will often be case law that's similar to, but maybe not exactly on the nose for what you're looking for, but there's a broad range of case law in this area. Also worth mentioning that unfair dismissal claims, currently you still need 2 years service to bring an unfair dismissal claim, although I should say actually 2 years less 1 week, because the 1 week statutory notice is added onto the period of service. So always remember, if you're getting really close to that 2-year margin, bear in mind statutory notice extends the period of service. So currently we're still at that status, but I'm sure lots of you will be aware the Employment Rights Bill is making its way through Parliament, and the proposal is that unfair dismissal will become a day one right if all those elements of the Employment Rights Bill come into force, as we expect they will. There has been talk and proposals that there will be a sort of an exemption / carve out for the first perhaps 9 to 12 months that would function similarly to a probationary period where the rules may be slightly different, but that doesn't apply to redundancies. So we currently expect that if and when the Employment Rights Bill becomes law, redundancy protection from unfair dismissal will be a day one right, which will be a big change in the UK. Next slide, please.
Thanks, Jo. Good afternoon, everyone. So I'm now going to move on to consider the first step in an individual redundancy process, which is to identify whether there has been a genuine redundancy situation. So this is very much the starting point, and naturally it's something that we will discuss with clients, very early on in the process, of the kind of the first part of the process. Looking at the legislation, so the legislation sets out what the definition of redundancy is, and it covers those 3 specific situations that we've got on the slides there. So the closure of a business, the closure of a particular place of work, and the diminishing need for employees to carry out work of a particular kind. So the closure of a business, the first one there is essentially kind of what it says on it, it says on the tin. So an employer ceases to carry on a business for the purposes of which an employee was employed. So it's quite straightforward in practice, and for that reason, it's, I suppose, the kind of easiest type of redundancy situation to identify. An example would be an employer that decides to, close down its entire manufacturing business because it's no longer economically viable, and therefore, as a result, it dismisses employees because of that. It's worth noting that the legislation does refers to kind of this cessation. So the word cease in the legislation can actually include a kind of temporary cessation of a business, as well as a permanent closure. And whether or not a temporary cessation of a business for redundancy purposes will essentially be a question of fact for a tribunal to determine. So that's the kind of more straightforward one. The closure of a particular place of work, unless it's, I suppose, obvious where an employee is employed to work, things can become more complicated if an individual's contract contains a mobility clause, for example, that allows an employer to change the kind of the place of work. And in such circumstances, there's a kind of case law that confirms that an employer cannot rely on the kind of mere existence of a mobility clause to avoid a redundancy situation. So there was a Court of Appeal decision in 1997 in the case of High Table versus Horst and others, where an employee's place of work was determined to be the place at which the employee is in fact employed to work before their dismissal, and not the place where the employer could lawfully require the employee to work. So I suppose it's that kind of hypothetical question, and they determined, the court determined that it was where the employee is actually working. If, however, and this obviously can happen, an employee's work requires them to work from different places, it's really important to kind of look at the kind of mobility clause and the wording within that clause. Can an employer actually invoke a mobility clause to avoid dismissing an employee as redundant? The answer to that question is yes, and there has been case law on this particular point. The case of the Home Office versus Evans, the Court of Appeal confirmed that an employer can invoke a mobility clause when a situation arises or might arise, and therefore can avoid a redundancy dismissal. An employer, however, must make it clear to the employee from the very outset that they're actually invoking this mobility clause. So what they can't do is start off with a redundancy process and then subsequently try to force the employees to move under a mobility clause. The issue did come up again in subsequent case law in the case of Kellogg Brown and Root. And here the EAT held that a tribunal had essentially erred in concluding that the employees had been dismissed by reason of redundancy. So there were two employees that were employed at a site in Middlesex. The business decided to close the site and instructed these employees to transfer to another site in Surrey. They had a mobility clause within their contract. The individuals refused because it meant they had a much longer commute, and they were subsequently dismissed for refusing to relocate. And they both brought claims of unfair dismissal and statutory redundancy payment. In those circumstances, the Employment Tribunal held that the dismissals were unfair, and it held that the dismissals were by reason of redundancy. However, the EAT, whilst it agreed that the dismissals were unfair, they said that the reason for the dismissal was actually misconduct. So the individual's failure to comply with the instruction to transfer and not redundancy. So as kind of Joe alluded at the start, it's very kind of fact specific. So it's important to kind of bear that in mind. In terms of the last point on the slides, the diminishing need for employees, this is often the most kind of problematic of this kind of three types of redundancy situation. The leading case is a case of Safeway stores v. Burrell. And there was a sort of three-stage test set out within this case for essentially determining whether there has been a reduction in the need for employees to carry out work of a particular kind. So the first question being, was the employee dismissed? If yes, has the requirement of that employer's business reduced, or was this likely to be so? And if yes, was the dismissal as a result of that reduction? And various of the cases have followed, which have adopted that similar test. So next slide, please. Points to kind of watch out for, I suppose, is first of all kind of a restructuring exercise. So I think difficulties often arise where there's a kind of business reorganisation or a restructuring exercise, and there's maybe this kind of reallocation of duties, or there's the same amount of work, but it's an employer maybe wants it to be carried out on different terms and conditions, or maybe by different employees. And I think that can be tricky because the question arises as to whether or not that actually is a redundancy situation. And if an employer is undertaking a reorganisation that falls outside the kind of statutory definition of redundancy, then it can rely on some other substantial reason, which is another fair reason for dismissal. So the sort of circumstances where, you know, employers, I suppose, should be really careful is, you know, where work is done, but it's under different terms and conditions, or it's the same work that's being done, but it's being carried out by sort of different employees, or in circumstances where the work actually changes, but it remains work of a particular kind. So very kind of, I suppose, key points to kind of bear in mind and be careful that you're sort of not caught out by. Another point to kind of watch out for is fixed term contracts. So in circumstances where a fixed term contract expires and then it's not renewed, that may constitute a dismissal by reason of redundancy if the reason for not actually renewing that contract is a reduction in the need for employees to carry out work of a particular kind. And I think sometimes that can sometimes be forgotten. If an individual has been on a fixed term contract and it just, you know, I think assumed that, you know, that contract comes to an end, I think there needs to be that consideration there as to whether or not it does actually qualify as a redundancy situation. And then the other one on the slide there is TUPE transfers. And the reason we've included this is really because I think employers need to take additional care when making redundancies in the context of a TUPE. Different kind of rules apply where there is where the transfer is the sole or principal reason for the dismissal, then it will be automatically unfair. However, this won't be the case where there is an ETO reason, so an economic, technical or organisational reason entailing changes in the workforce. So the next point that we wanted to chat through is bumping. So this comes up a lot. We get a lot of questions from clients on bumping. And essentially, bumping is where sometimes when an employee's role is redundant, another employee will be dismissed in order to make way for them. And yeah, it's essentially referred to as bumping or bouncing out. And it's clear from the case law that this dismissal, this can be a dismissal for redundancy, even though there's not been a reduction in the need for employees to carry out work done by the individual, by the employee who's actually dismissed. So the sort of key sort of case on bumping is the case of Mirab and Mentor Graphics. And essentially in this case, Mirab held a standalone sales role, a sales director role. The employer, Mentor, decided they no longer needed that role. There were some kind of earlier discussions with Mirab about kind of departmental structure, and you know, he sort of kicked against any kind of implied demotion to an account manager role. But when it actually came to the proposed redundancy, in the consultation meeting, Mirab actually made reference to dismissing the account manager instead. And I think in practice, you can sort of see where this situation could happen a lot. Redundancy consultations are not easy consultations, they're not easy meetings to have. And I think it's quite natural for somebody to maybe say, well, so-and-so isn't being made redundant, why am I? So I think it's important to remember that whilst employers are not obliged to bump, a failure to even consider bumping can sometimes be fatal to the fairness of a dismissal. And again, it goes back to the point of situations being very fact specific. And I think from a kind of practical point of view, our advice to clients is, when selecting employees for redundancy, it's important to consider whether that employee in question could be offered an alternative position, even if it's a subordinate position, or if it means dismissing another employee. And I think these situations typically tend to arise where an employer is proposing to make a senior role redundant but retain a more junior role, and that's typically when we see bumping happening. So moving on to the second step then of the process, which is selection. So as we know, redundancy is a potentially fair reason for dismissal, but it is important that employer carries out a fair process as well if, as Jay mentioned, the employer wants to avoid a finding of an unfair dismissal. So in terms of selection, employers should bear in mind or should ensure that they identify a pool and the pool is identified correctly. They should also ensure that selection criteria are, as far as possible, objective, and also that any selection criteria are applied fairly. So the first thing an employer would need to do is consider the pool of employees from which those who will need to be made redundant will be essentially selected from. So where an employer is closing down its entire business or a particular place of work, the kind of question of pool is usually quite straightforward. It doesn't usually arise because all employees will be potentially redundant unless alternative employment can be found. The case isn't quite as straightforward when selecting a pool in other circumstances. So if is there, for example, so points I suppose that employers should bear in mind is whether there's any kind of agreed procedure in place governing whether employees should be included in the pool. So maybe there's an agreement with a union. If there is, then employers should usually adopt this procedure unless the employer can show that it was reasonable for them to have not done so. Also, the type of work that an employee carries out. So if employees do jobs that are maybe interchangeable, or there are kind of similar or similar duties or the same type of duties, then employers should consider kind of widening the pool to include these employees. I think what's important to kind of bear in mind as well is a tribunal will judge an employer's choice of pool by asking whether it fell within that kind of range of reasonable responses. So employers do have a certain amount of flexibility, which is helpful in terms of determining, what the pool looks like. And a narrow pool is obviously going to be challenged by an employee, whilst a kind of wider pool is probably going to result in a more kind of lengthy selection exercise. So, the idea is hopefully to kind of get some sort of, middle sweet spot, which again is probably trickier said than done. There are sort of two kind of recent cases, McGain and Bradford Teaching Hospitals and Ballymullah versus Care Foundation. These are both cases in the last couple of years that really highlight the importance of kind of giving really careful thought to the pool that employees should be selected from for redundancy, especially where there's a pool of one. So employers really need to think about whether the role is genuinely self-selecting or whether there are potentially other employees that can be included in that pool for selection. So I think that's not to say that, a pool of one can never be used, but really just, employers should give thought as to whether or not that's appropriate. And again, that kind of goes back to the point of, keeping paper trails of any kind of thought process around that decision making in terms of the selection pools. So moving on to selection criteria then. So once you've identified the selection pool, employers then need to consider the sort of criteria that need to be applied. And the key thing to kind of bear in mind here is to ensure as far as possible that the criteria are objective and that they are applied fairly. So any sort of selection criteria that maybe involves sort of kind of personal judgment can be appropriate, but only really if they're applied in a kind of objective manner. And I think it's worthwhile flagging that it's not always possible to draw up a sort of definitive list of selection criteria. And I think we do often have questions from clients asking us to provide them with a list of selection criteria, and it very much will depend on the business, and obviously the facts will differ and depend on the employer's kind of arrangements and their individual needs. But it's important that employers adopt a kind of consistent approach and have very kind of clear rules about what can and cannot be taken into consideration. So we've set out on the slide here some of the sort of more commonly used criteria. So skills, performance of skills, which is kind of, I guess, a very straightforward one. I think it's worthwhile flagging here that it's important to sort of be careful that skills are assessed objectively, and there's no kind of focus on an employee's attitude, for example, which kind of might be subjective and therefore quite difficult to measure. Attendance records is another kind of common one that we see used a lot, but as you'll be aware, you need to be really sort of careful about excluding any kind of absences that may be for pregnancy-related sickness to avoid any kind of potential discrimination claims, and also, potentially any sort of disability discrimination claim that could arise if absences are for a disability-related reason. So more often than not, an employer may actually be able to kind of adjust the criteria if employees have a disability. Disciplinary records as well is a common one, and again, our kind of advice is to use any disciplinary records based on or take into account only live warnings. So not consider any sort of expired warnings. And one way of doing this is to kind of give points on a score of 1 to 5, depending on the kind of seriousness of the warning. We've also included there last in, first out, and you'll see there's a little question mark there. And I think historically it was quite common to include length of service as a criterion, but this can lead to sort of claims of indirect age and sex discrimination. So now only tends to be used really in a kind of a tie-break situation, if at all. And the reason we talk about, I suppose, redundancy selection criteria, and the importance is because of the implications of I suppose, choosing selection criteria inappropriate. The legislation sets out a sort of list of kind of grounds on which selection for redundancy will be automatically unfair. So, for example, selection which is connected to pregnancy or childbirth or whistleblowing. And obviously, in those circumstances, employees don't have to have a qualifying period of service to bring an unfair dismissal claim. And equally, if, as I've kind of alluded to, if any criteria do discriminate on the grounds of race, sex, disability, and the other protected characteristics, then it will an employer could face discrimination claims as well as potentially unfair dismissal claims as well. Also, point to note around being careful around part-time and fixed-term employees as well, because there's a potential there for for claims on the back of selecting an individual who's part-time or fixed term. So in terms of kind of I guess the process, the best practice really is to have a sort of matrix and have a kind of score sheet that attaches a certain weight and score to each criterion, so that you're essentially giving each employee a final score on which ultimately the decision for redundancy is then based. And when all those scores have then been worked out, those employees with the lowest scores will be the ones who are provisionally selected for redundancy. We do sometimes get questions around whether employees are entitled to see the scores of colleagues in a redundancy scoring exercise, and the answer is usually no. And I suppose the key issue is whether the employer can show that the method of selection was fair, but there has been case law to confirm that it's not for a tribunal to kind of go through a scoring system essentially and determine whether or not the scoring system that was used was appropriate, so as to not kind of reopen questions as to kind of how it had been done. And again, that kind of goes back to the point around employers having that kind of degree of flexibility. I think as a sort of, I suppose, as a sort of general rule, when it comes to, say, for example, individuals that are on maternity leave, I think employers can sometimes be concerned if there's an individual who's pregnant or on maternity leave. The best kind of practice is to carry out an assessment based on actual performance. So if, for example, one of the criteria is an individual's ability to hit sales targets, and then prior to maybe that individual going on mat leave, the individual has hit their sales targets, then that individual can be treated as if they've met their sales targets during that relevant period. In terms of mentioned about the kind of not looking at sort of attitude to work and these kind of very subjective criteria of kind of best suited to the needs of the business. I think a key consideration, or a kind of a best top tip, is to really have HR involved in the process, and it's worth HR kind of going through that list of at-risk individuals to identify any who are or have been on maternity leave or kind of long-term sick leave, to ensure that their selection hasn't been inadvertently influenced by any sort of discriminatory factors. One thing that kind of we come across sort of on a regular basis is where managers aren't necessarily able to kind of point to kind of hard evidence. So where there's no kind of records or you know, maybe appraisal forms to kind of support any scores. And that, you know, that is quite common, and that may be because an individual maybe has been underperforming, but it hasn't been managed. I had a situation last year where we had a business that had only kind of recently set up, so they didn't actually have a performance appraisal process implemented, and they were obviously going through a redundancy process, but didn't have anything to actually point to. So I think it's important that kind of HR are involved in those processes to kind of oversee the scoring process to make sure it's being carried out consistently, and that, you know, to the extent possible, managers can kind of point to something like concrete to actually support any assessments, and they're not just kind of relying on their sort of judgment or gut feel. And then a final point to note, and I think mentioned it briefly, is just to really keep an audit trail of any discussions in case there's any challenges. In the event, you know, there's an unfair dismissal claim, it's useful to be able to refer back to those discussions.
Thanks, Danny. So moving on now to step 3, which is the requirement to consult with the individual about the proposed redundancy. Consultation is essential. Without it, it's highly likely to be an unfair dismissal. There was a 1998 Court of Appeal case called Warner and Adnet, when a judge said very eloquently that tribunals should scrutinise with the greatest care any case where an employer makes a dismissal without consultation, and should carefully examine excuses such as they had no time to consult or that there was no point in consulting. So a heavy steer from the Court of Appeal: consultation is important. The aim of the individual consultation is to explain to the employee why they've been provisionally selected for redundancy, give them an opportunity to express their views, give them an opportunity to raise questions and give their feedback, and then talk about alternatives, which obviously includes suitable alternative positions, which we'll come on to in some more detail. In small-scale redundancies, the best practice is for the company to make an initial announcement to all potentially affected employees, effectively telling, usually it's a group of employees, unfortunately you were all at risk of redundancy, this is our rationale, then carry out the selection, and then consult individually with those who have been provisionally selected, and give those people their opportunity individually to comment on their scores and the rationale for redundancy, and discuss their suggestions and alternatives, etc. So that is the kind of gold standard for carrying out a small-scale redundancy. In practice, what we often find is that companies prefer to miss a step. So they don't want to unsettle a large group of employees by putting everyone at risk and risking some, you know, you can have key employees being told they're at risk of redundancy and starting to look elsewhere. And it creates, you know, an atmosphere of uncertainty in the business. So it's not uncommon for employers to say, we're not doing that part, we're going to do the selection behind the scenes effectively straight off, and then we will just consult with those that have been provisionally selected, having carried out that selection process. It's possible, people do it commonly. There is always a risk of predetermination because the purpose of the consultation, it has to be meaningful and genuine, and there has to be the possibility that those people provisionally selected are not ultimately made redundant, because there must be, at least theoretically, the possibility that they could successfully challenge their scores and effectively reverse the decision, meaning somebody else would be selected. And if that somebody else hasn't been even told that they were at risk of redundancy, that can obviously cause you problems. So there are commercial reasons for taking the second approach. The best practice is always the first approach. But obviously that's not always how the world works, is it? The other thing to mention in this one is this case called DeBank-Haycox, which ruffled feathers in the employment law world last year when it came out. We had a team meeting about it. We were all quite concerned. So this was a case where Mr. DeBank-Haycox was provisionally selected. They took that second approach. He was provisionally selected from a group of sales associates and invited straight in to a consultation meeting. He was not told his scores, and it later transpired, or the tribunal found, that the scoring method was entirely subjective. So the company had done a really subjective scoring process. They invited him in, they had some meetings with him, and he was dismissed. Because he wasn't told his scores, it was almost impossible for Mr. DeBank-Haycox to argue against his redundancy. So there was an appeal which was not successful, and he brought an unfair dismissal claim. At the employment appeal tribunal stage, the EAT found consultation had taken place far later than the formative stage, and it was therefore not reasonable. They found the appeal process did not correct that defect. And then they made some really unhelpful comments saying that there should have been general workplace consultation before individual consultation with Mr. DeBank-Haycox, to get input from the workforce as a whole. So kind of moving individual redundancy consultation much closer to a collective redundancy consultation. And this outcome, this EAT decision, it didn't tell us exactly what that meant, this general workplace consultation, but it felt crazy that you might have one individual potential redundancy and you'd have to consult with the whole workforce about it. That was the state of the law for a brief period, and then thankfully it was overturned by the Court of Appeal, who said that if it is considered that there should be additional consultation requirements in small-scale redundancies, that would be something to be addressed by legislation or by ACAS producing some kind of guidance, but it shouldn't be produced on the hoof by the courts. So that's helpful in that there is no requirement for general workplace consultation as the EAT suggested. I think it's also worth noting the reason the EAT decision came out the way it did seems more likely than not to have been because the employer did follow a fairly poor process. They did very subjective scoring. They didn't tell Mr. DeBank-Haycox's scores. There were a number of areas where they were defective, and it feels like that's what led the EAT to go off on this slight tangent of deciding that all employers should do general workplace consultation. So that's no longer the case, thankfully. So in individual consultation, there's no requirement for the employer to agree with the employee, but it must be seen to be genuinely considering what the employee says. So for this reason, we would usually advise employers to have at least 2 consultation meetings, so not including the at-risk meeting. You would have at least 2 consultation meetings with a gap of several days, and you have to look into any points or any counter proposals that the employee makes and come back on those, so they can't just be disregarded out of hand. It may be the case that a further meeting is required if the employee comes to the suggested final meeting with something else. It's ultimately it can be frustrating, but you have to think of it as protecting the business in kind of allowing the employees time to put forward their suggestions and for the business to consider them. I think Danny has already mentioned it, but you must always remember absentees. So employees who are absent on maternity leave or long-term sick leave or any other kind of long-term leave, you should remember they need to be informed of any potential redundancies, ideally as receiving the same information at the same time as the rest of the employees, so you're not treating them differently. You have to kind of manage your timelines in that respect, but the important thing is to give the same information where possible. We have seen a couple of cases where, with all good intentions, employers have decided to leave employees on maternity leave out of a redundancy consultation and kind of say, oh, we want them to enjoy their maternity leave, so we'll just deal with them when they come back. And I think sometimes that is an admirable intention, but it's legally a very risky and not a correct way of doing things. So although you might be disrupting the maternity leave, it's important these people are given the information at the time. And in terms of people on long-term sick leave, as always, you should consider adjustments to the process. So particularly if this long-term sick leave is linked to a disability, you might need to think about adjustments to the way you hold any meetings or how you deliver information to them, any extra support they might need as the process goes on. Now, in terms of timescales, there is no fixed period if you're under the collective consultation threshold. Companies will often come to us and say, what is the minimum period for which I can do an individual consultation process? There's no minimum period. The important thing, it must be genuine and not a sham. We would say the absolute minimum you could get away with would be a week if you put employees at risk on a Monday, gave them the letter on a Monday, had the first consultation meeting on Wednesday and the final consultation meeting on a Friday, and then you'd have to have an appeal. So that would be just about possible, but that really is the minimum you could ever manage. It's often not possible. Employees might put forward counter proposals. They often go off on sick leave. If you're working to a strict time frame, you have to build in some buffers for things that you just don't know, unforeseen events that actually are quite common. Also worth checking your contracts and your policies in terms of timescales, because you might have some commitments in there, and you should obviously honour anything in your contracts or policies. If you're not going to stick to what's in a policy about timescales, you should always have a good reason for doing so and be able to explain it. And then some practical tips, which are probably obvious, but bear repeating. Take good notes of consultation meetings. At the end of the meeting, as at any meeting, the final question should always be, do you have anything else you want to say? So you close off those arguments down the line of, but I didn't get to raise this point or that point. Don't try to agree the notes with the employee. You just get into back and forth and they're never going to agree. That sounds cynical, but it tends to be what happens. It's just a waste of time. And then always remember, anything you write down in that kind of formal setting is potentially disclosable. We've seen doodles be disclosed, so be very aware of the notes that you're creating in that kind of formal setting. Next slide, please. So a word on alternative employment. Employers must take reasonable steps to find alternative employment, and a failure to do so can render a dismissal unfair. What is reasonable in terms of the reasonableness of the steps? That's a question for the tribunal to decide, but it would certainly include identifying vacancies and inviting an employee to apply for any that are potentially suitable for them. There was a case this week I saw called Hendy Group and Kennedy, where a dismissal was found to be unfair because the employer had made no real efforts to assist this redundant employee in finding alternative employment. So they gave him no help and guidance in applying for roles or identifying suitable roles. They told him he would be unsuccessful if he did apply. They didn't try to match him with any roles. HR didn't tell the managers that he was at risk of redundancy. There was a whole catalogue of things that they could have done and didn't do, rendering his dismissal unfair on the basis of this failure to comply with the duty to look for suitable alternatives. And an employer should not assume that a vacancy would be unsuitable because of a change to location or salary. It's not for them to make those assumptions. So the safest thing to do is to provide details of all vacancies and also to make suggestions of any that are appropriate to that individual. A question that often arises, and it's a tricky one, is whether there's an obligation to search within other companies in the same group. There's case law that conflicts on this. Some of it's really old. So there's an old case from 1973 called Vokes, where it was an unfair dismissal because the company failed to look for alternatives within this group, which is a large group of 300 or something companies. There's another case in 1984 which said it was not unfair, where the company did the opposite and where the company limited their search to just the employing entity, so it found the opposite. And then a more recent case from 2021, Gwynedd and Barrett, saying that associated employers should be included in the job search. So the position on that is still not 100% clear. If you're considering that, it would be good to have rationale for making your decision one way or the other, because the case law isn't particularly helpful on that one. One really important point to watch out for in terms of alternative employment, next slide, please, is the obligations under Regulation 10 of the Maternity and Parental Leave Regs, which everyone just calls the Reg 10 right. That is, employees who are pregnant on maternity leave or during the additional protected period, which was extended last year, they have the right to be offered a suitable vacancy. So that's not to apply for, it's to be offered first refusal. So they jump to the front of the queue. It used to be just during maternity leave, but now it's during pregnancy, maternity leave, and some time after they've returned to work, so 18 months after the birth. To be suitable, the work must be suitable and appropriate, and all the terms and conditions must be not substantially less favourable. So there's a useful case demonstrating that it's for the employer to decide whether the alternative role is suitable or not. It's not for the employee to decide. And this was a case where an individual was at risk of redundancy, located in London. The employer had a vacancy, but it was in Cheltenham. They decided not to offer her that vacancy because the distance was too great for it to be considered suitable. It so turned out that this employee actually would have been very happy to move to Cheltenham. She had links there. She was quite keen on the idea. So she brought a claim saying it was unfair that she hadn't been offered this Cheltenham role. And the tribunal said that the Reg 10 right was for the employer to decide what was suitable. So she did not have the right to be offered that Cheltenham role. An interesting one. And then also the case that's on the screen, Carnival and Hunter. This is useful because there is some nuance in when that Reg 10 right applies, and it is when there's a suitable vacancy, but not where there's just a reduction. So if you have 10 employees all doing a similar role and they are all at risk of redundancy and you only need 5, you're just cutting from 10 to 5, Regulation 10 is not triggered because there aren't vacancies, there aren't new roles, you're just reducing the numbers. If you have 10 roles and they're all at risk of redundancy and you're creating 5 new different roles that those people can apply for, if you have one of those people, one of the 10 at risk who is pregnant or within that protected period, they do have the right to jump the queue for those new roles. So that's an important distinction to be aware of. And it's very relevant when you're looking at selection pools and what is it a reduction genuinely, or is it actually new roles being created? And also that right also applies to those returning from adoption leave and shared parental leave. Okay, I'm conscious of time, but we'll get there. Suitable alternatives in terms of trial period. So if an employee is offered an alternative role where the terms and conditions differ in whole or in part, they are entitled to a statutory trial period. That's not optional. It applies as of right. It's for 4 weeks. It can be extended, but only for the purposes of retraining. If the employee is successful in the role, they stay in the role, there is no redundancy payment, they just keep their new job. If the employee terminates the new role during the trial period, they are treated as though they were dismissed on the date the original contract came to an end, and they get their statutory redundancy payment. The same thing if the employer terminates during the trial period for unsuitability, the dismissal reverts to the dismissal of the initial role, not the trial period, and they get their statutory redundancy payment. If the employer terminates for a different reason, so if the employee commits gross misconduct during the trial period and is dismissed for that, that's a different reason for dismissal. They do not then get the statutory redundancy payment. It is possible to agree a longer trial period, but it means you fall outside the statutory regime, and it becomes a lot more complex if you eventually want to decide that the role is not suitable on either side. You don't necessarily then have the redundancy as a reason for dismissal, and you might have to go back and do it all again or do a performance dismissal. So that is quite a risky area. So we would recommend taking legal advice if you're ever going to extend a trial period beyond the statutory trial period. If the employee unreasonably refuses an offer of suitable alternative employment, they lose their right to statutory redundancy payment. And it's on the onus in this case is on the employer to show that the offer was suitable and refusal was unreasonable. There's both subjective and objective elements to that test. One question that can arise in these individual redundancy type situations is what happens if an employee wants to leave during their notice period? So if they're on garden leave or working out their notice and they want to go to another job, do they still get their redundancy payment? And the answer to that is yes, if the employee and the employer agree to vary the notice period, and or potentially yes, if the employee complies with the extremely complicated provisions around counter notice. So an employee can serve counter notice to bring their employment to an end earlier and retain the right to their redundancy payment. However, the employer can then serve a counter notice as a counter notice. It gets very complex. If you get into that situation, again, I won't go into it all in detail now. Recommend you get specific legal advice on that point. Next slide, please. And then getting to the end stage of the process, you are at dismissal. As I've already mentioned, the ACAS code does not apply. The right to be accompanied is from Section 10 of the Employment Rights Act 1999, which says that workers have the right to be accompanied by a TU rep or a colleague at any disciplinary or grievance hearing. But disciplinary hearing is defined as one that could result in a formal warning or other action being taken. We would say that the Reg 10 right does apply to redundancy meetings. It's true that the worker must make a request to be accompanied, but we would say it's good practice to remind them of that. And so you should allow employees to be accompanied, particularly to the last meeting at which they're going to be dismissed. The consultation meetings where there's no decisions being made, arguably the right doesn't apply to them. Although a lot of the time you kind of think, what's the harm to allow them to be accompanied if they want to be? At the at-risk meeting, you would never really allow the right to be accompanied just because practically you don't often tell employees about the at-risk meeting. It happens. The right of appeal, not offering a right of appeal is not fatal to a redundancy, not necessarily an unfair dismissal. There have been cases on this, but it is best practice, and we would always advise offering a right of appeal and confirming the decision in writing. And then finally, redundancy payments. Employer must pay a statutory redundancy payment if the employee has 2 years service. There is a statutory formula. It's capped currently at £719 a week. The employer must provide a statement setting out the calculations. A failure to do this is a criminal offence, believe it or not. And then enhanced payments. Statutory redundancy payments tend not to be huge, so it's often the case that employers will offer enhanced redundancy payments. But if you do that, we would recommend that you do it as discretionary and, if possible, subject to signing a settlement agreement so that you are ideally not setting a precedent via custom and practice. There have been many cases around that. If you make the same redundancy payment in the same way without varying it, it can be found to become an implied term via custom and practice. So to avoid that, it helps if you're able to vary it on different redundancy exercises. Mention that it's discretionary, ex gratia, subject to contract, subject to settlement agreement, if possible. And then on the next slide, please, collective consultation. I won't go through this in detail because we're nearly at time, but just to remind you, very different rules apply where 20 or more redundancies are proposed in one establishment within a 90-day period. There are minimum consultation periods, and failure to comply has significant penalties. Again, likely to change under the Employment Rights Bill, so watch this space on that one. So we are nearly at 1 o'clock. Thank you all very much for attending. We won't, unfortunately, have time to get to any questions, which I suspected would be the case just because of the amount of content we had to get through. So thank you all very much for attending. We do appreciate it. We will likely do a follow-up blog where we can answer your questions. But if you have anything specific, then please do feel free to reach out to us. As we've mentioned, we will be sending a link to the slides and a recording, or a copy of the slides and a link to the recording, so you will have those when they have our contact details on them. So all that remains to say is thank you very much and enjoy the rest of your day.